Power of attorney. A power of attorney is a written authorization for an individual to receive confidential tax information from the IRS and to perform certain actions on someone else's behalf. If the authorization is not limited, the individual generally can perform all acts that they can perform except negotiating or endorsing a check. The authority granted to enrolled retirement plan agents, enrolled actuaries, and unenrolled return preparers holding records of completion is limited. Acts that can be performed. Attorneys, certified public accountants, and enrolled agents may perform the following acts. Represent taxpayers before any office or employee of the IRS. Sign an offer or a waiver of restriction on assessment or collection of a tax deficiency, or a waiver of notice of disallowance of claim or refund. Sign a consent to extend the statutory time period for assessment or collection of a tax, and sign a closing agreement. Signing a return. The representative named under a power of attorney is not permitted to sign an income tax return unless the signature is permitted under the Internal Revenue Code and related regulations, and they have been specifically authorized to sign in the power of attorney. The regulations permit a representative to sign a return if the taxpayer is unable to sign the return due to these situations: disease or injury, continuous absence from the United States, including Puerto Rico, for a period of at least 60 days prior to the date required by law for filing the return, and other good cause if specific permission is requested of and granted by the IRS. When a return is signed by a representative, it must be accompanied by a power of attorney or copy authorizing the representative to sign the return. Limitation on substitution or delegation, disclosures, and incapacity. A recognized representative can substitute or delegate authority under the power of attorney to another recognized representative only if the act is specifically authorized by the power of attorney. After a substitution has been made, only the newly recognized representative will be recognized as the taxpayer's representative. If a delegation of power has been made, both the original and the delegated representative will be recognized by the IRS. The representative cannot execute consents that will allow the IRS to disclose tax return or tax return information to a third party unless that authority is specifically delegated to the representative on Form 2848. A power of attorney is generally terminated if the taxpayer becomes incapacitated or incompetent. The power of attorney can continue, however, in the case of incapacity or incompetency, if so authorized on Form 2848, and if the non-IRS durable power of attorney meets all the requirements for acceptance by the IRS. When power of attorney is required. As a practice, submit a power of attorney to authorize an individual to receive confidential tax information and represent the taxpayer before the IRS, whether or not the representative actually performs any of the acts that were discussed earlier in our presentation. A power of attorney is most often required when authorizing another individual to perform at least one of the following acts on behalf of a taxpayer. Represent a taxpayer at a meeting with the IRS. prepare and file a written response to an IRS inquiry. Use IRS Form 2848 to appoint a recognized representative to act on behalf of a taxpayer before the IRS. Individuals recognized to represent taxpayers before the IRS are listed in Part 2 of Form 2848. The representative must complete that part of the form. Here are some of those individuals recognized to represent: attorneys, certified public accountants, enrolled agents, an officer of a corporation, a general partner of a partnership, a full-time employee of the taxpayer, a family member, that's immediate family, spouse, parent, child, grandparent, grandchild, step-parent, stepchild, brother, or sister, enrolled actuaries, and unenrolled return preparers. Now, in terms of unenrolled return preparers, the authority to practice before the IRS is limited. An unenrolled return preparer may represent, provided the preparer, number one, prepared and signed the return or claim for refund, two, was eligible to sign the return or claim for refund, three, has a valid PTIN, four, possesses the required annual filing season program record of completion. Also, in some cases, qualifying students can represent, and enrolled retirement plan agents can act on behalf of another taxpayer or of a taxpayer. Non-IRS power of attorney. The IRS will accept a non-IRS power of attorney, but a completed Form 2848 must be attached in order for the power of attorney to be entered on the Centralized Authorization File, or CAF system. To use a document other than Form 2848 to authorize the representation, it must contain the following information: taxpayer's name, address, social security number, ITIN or employer identification number, name and mailing address of the representative, types of tax involved, federal tax form number, specific year or periods involved, and a clear expression of intention concerning the scope of authority granted to the representative. It must be signed and dated. Attached to the non-IRS power of attorney, a signed and dated statement made by the representative. This statement, which is referred to as the Declaration of Representative, is contained in Part 2 of Form 2848. The IRS will not accept a non-IRS power of attorney if it does not contain all the information needed. If the taxpayer cannot sign an acceptable replacement document, the attorney, in fact, may be able to perfect, which means to make acceptable to the IRS, a non-IRS power of attorney by using the following procedure. Under the following conditions, the attorney, in fact, named in the non-IRS power of attorney, can sign a Form 2848 on behalf of the taxpayer. The original non-IRS power of attorney grants authority to handle federal tax matters. The attorney, in fact, then attaches a statement signed under penalty of perjury to the Form 2848 stating that the original non-IRS power of attorney is valid under the laws of the governing jurisdiction. So when can a non-IRS power of attorney be submitted? Well, a signed 2848 is signed on behalf of the taxpayer. The original non-IRS power of attorney specifically granted the authority to handle federal tax matters, and the attorney in fact attaches a statement under penalty of perjury that to the 2848 stating that the original non-IRS power of attorney is valid under the laws of the governing jurisdiction, such as a state. Updating a power of attorney. Submit any update or modification to an existing power of attorney in writing. A recognized representative may substitute or delegate authority if specifically authorized to substitute or delegate representation in the original power of attorney. To make a substitution or delegation, the representative must file the following items with the IRS office where the power of attorney was filed: a written notice of substitution or delegation signed by the recognized representative, a written declaration of representative made by the new representative, and then a copy of the power of attorney that specifically authorizes the substitution or delegation. So those three items need to be included with a substitution or declaration, or delegation, I should say. Retention, revocation of prior power of attorney. A newly filed power of attorney concerning the same matter will revoke a previously filed power of attorney. However, the new power of attorney will not revoke the prior power of attorney if it specifically states it does not revoke such prior power of attorney, and either of the following are attached to the new power of attorney: a copy of the unrevoked prior power of attorney, or a statement signed by the taxpayer listing the name and address of each representative authorized under the prior unrevoked power of attorney. The filing of Form 2848 will not revoke any Form 8821 that is in effect. So the 8821 would stay in effect. To revoke a previously executed power of attorney without naming a new representative, write "revoke" across the top of the first page of Form 2848 with a current signature and date immediately below this annotation. If a representative wants to withdraw from representation, he or she must write "withdraw" across the top of the first page of Form 2848 with a current signature and date immediately below the annotation. When power of attorney is not required. A power of attorney is not required when the third party is not dealing with the IRS as representative. The following situations do not require a power of attorney: simply providing information to the IRS, authorizing the disclosure of tax return information using Form 8821, allowing the IRS to discuss return information with a third party via the checkbox provided on a tax return or other document, allowing a partnership representative to perform acts for the partnership under the centralized partnership audit regime for tax years beginning after December 31, 2017. Allowing a tax matters partner to perform acts for the partnership for partnership tax years ending prior to January 1, 2018. And then allowing the IRS to discuss return information with a fiduciary. If we remember from other presentations, a fiduciary is not per se a representative. They really act as the taxpayer. Let's look at some questions. Janet is not an enrolled agent, CPA, attorney, or enrolled actuary, and has never held a record of completion. So this is an unenrolled preparer who has not held a record of completion. In 2018, the president of Widgets R Us engaged Janet to prepare the company's 2017 Form 1120-S. Janet prepared the 2017 income tax return for Widgets R Us and signed it as the preparer on April 10th, 2018. This is the only return Janet prepared for Widgets R Us. In December 2019, the IRS began an examination of Widgets R Us 2016 and 2017 returns. So in December 2019, the IRS began an examination of 2016 and 2017 returns. Janet has a power of attorney to represent Widgets R Us for 2016 and 2017. Under Circular 230, Janet is permitted to represent Widgets R Us during the examination with regard to its 2016 return, 2017 return, 2016 and 17, or none of the above. The correct answer is none of the above. Janet is an unenrolled preparer who is not an annual filing season program certificate of completion holder. Therefore, she has no ability to represent any other taxpayers in her role as a tax professional. Phil, an enrolled agent, prepares William's income tax return. William gives Phil power of attorney, including the authorization to receive his federal income tax refund check. Accordingly, the IRS sends William's $100 refund directly to Phil's office. William is very slow in paying his bill and owes Phil $500. Phil should use William's check as collateral? Absolutely not. Refuse to give William the check until he gets paid the $500? Absolutely not. Get William's written authorization to endorse the check, cash the check, and reduce the amount owed to $400? Absolutely not. One thing that's prohibited is the negotiating of any refund checks. Item A, item B, item C, all are very much prohibited. The only correct answer is to turn the check directly over to William. And finally, a power of attorney is required in all of the following circumstances, except to furnish information at the request of the IRS. Yes, that's appropriate. We don't need a power of attorney to furnish information at the request of the IRS. We do need power of attorney to authorize the extension of the statute of limitations. We do need a power of attorney to execute a closing agreement under Section 7121, and we need a power of attorney to represent a taxpayer before any office of the IRS. We hope this video recording was helpful as you prepare for the enrolled agent exam.